Hey everybody. So today we are going to be covering the Tennessee Purchase and Sale Agreement. We're going to go over every page of the contract and every clause, and then at the very end, I will stop sharing, stop recording, and open it up for discussion, questions, and comments. So let's get into it. So some basic concepts, just sort of good to kind of always keep in mind. The contract is the only thing that matters. So if it's not in the contract, it technically doesn't matter. The contract can be accepted and is still voidable. And an offer is countered, a contract is amended. Special stipulations will need the following: who, what consequences will happen if something's not done, and may need to be contractually removed. So you always want to be specific. Okay, so number one, just an important reminder, this contract is used for any residential purchase of a property that has 1 to 4 units. So the purchase price and sale. So line 3, you're going to place the buyer's legal name as seen on their driver's license. Please verify spelling. Line 4, you're going to place the legal name of the persons or entity that owns the property. Their name should match the recorded deed. Lines 6 to 8, you're going to input the full property address, the deed book, and page numbers. And to find this, you'll need to go to MLS and search for the tax data. You can also search realtrax.com for any property to find the deed book and numbers. Lines 9 and 10, here you'll put either the legal description or the tax ID number. You can get this from the tax data as well. Line 10, you can leave this blank, but it's good practice to fill in as many blanks as possible. Most agents will put the legal description, but you could also put the MLS number. A covers the included items. So this section is going to cover what's included as part of the property sale. When you're at the listing appointment, you want to go through this section with the sellers. You want them to know and understand what exactly is included when they sell their home. Shutters, blinds, curtains, etc. are included in the contract by default, and many people don't know that. If one of these default items has sentimental value before listing, and especially before the property photos are taken, these items need to be removed and possibly replaced so there's no confusion. One appliance you won't see listed here is a refrigerator because it's always like 50-50 if people want to take it or not. And the same goes for the washer dryer and any above ground pools. If there's anything else, it's going to go on lines 23 and 24. Some agents in this section will write all appliances, but please don't do that because it's not going to be specific enough. For example, does all appliances include the washer dryer, the fridge? It just opens up the contract for too much interpretation. Everything just has to be very detailed and clear. In C, you're going to list the items that will not remain. So whatever you fill in here will override whatever is written in lines 12 to 21. And D is going to cover leased items. So always ask the sellers if there's anything of importance leased and make sure the buyer checks if they do not want leased items. Purchase price, method of payment, and closing expenses. The buyer acknowledges they will bring sufficient cash to the closing and put the purchase price here. Financial contingency loan. So if the buyer is putting down 20%, that means 80% of it is the loan, and that exact amount is going to go here. Lines 49 to 54. This says that the contract is contingent upon the buyer getting a loan. If the buyer is unable to secure the loan, but they acted in good faith, they can cancel and get their earnest money back. If the buyer were to go out and buy, say, a Lamborghini and then not qualify for the loan because of that purchase, that would not be acting in good faith, and they would be at risk of forfeiting their earnest money deposit. If the buyer cannot get qualified, the seller can request documentation regarding the loan denial. Lines 55 to 58, you're going to check which loan they're getting. Don't leave this blank. Lines 59 to 62. If the buyer has applied for a loan with the initial lender and they are denied, the buyer has the option to apply with a different lender and keep the terms and closing date the same. It's not required, but it's an option. So if the buyer does go out and find a new lender who can finance a loan option, they must close with that lender to continue the contract. Loan obligations, lines 64 to 84. The loan application must be filled 3 days after the agreement date, must be filed. Proof of the application and order of credit report should be sent to the seller's agent. Within 14 days after the agreement date, the buyer must give written notice that they have secured hazard insurance, notified the lender of their intent to proceed with the loan, has the available funds, and has requested an appraisal to be ordered. The buyer will apply for the loan in good faith. The buyer will provide requested documents to the lender as and whenever requested. The buyer asserts that unless otherwise stated, the loan is not contingent upon the sale of another property. And the buyer agrees to not make any large changes in their financial standing that might affect their ability to qualify. An important note here is if your buyer is not meeting these deadlines, the seller can give you 2 days to correct them and then terminate the contract. B covers the financing contingency. So if your buyer is paying cash, you're going to check this box, put bank statement in the blank, or whatever, other way they're going to be able to verify their funds. C is the appraisal. So choose whether this agreement is or is not contingent upon the appraised value, either equaling or exceeding the purchase price. If the home has been appraised for the purchase price or higher, it's always best to let the seller's agent know. It's good practice and considered common courtesy. If the home doesn't appraise, the seller can ask for documented proof. Lines 106 to 116, the buyer must promptly notify the seller if the home doesn't appraise. And the buyer has 3 days to either waive the loan contingency and move forward with the contract or cancel the contract altogether. If the buyer fails to act on either of these within the 3-day time frame, cancellation based on the appraisal is no longer an option. D covers closing expenses. So the buyer and seller must pay all fees associated with either side of the transaction. Failure to follow this policy will result in defaulting on the agreement. And title expenses. So you're going to put which party is paying for the title search, mortgage policy, and owner's policy. In a seller's market, buyers will often pay for these and will use it as a tool to make their offer appear more attractive. And this is, of course, negotiable. Line 149 to 154. If the verbiage on the seller and buyer expenses needs to be amended in any way, that's going to go here. Lines 155 to 157. So often in Tennessee, the buyer and seller will close at different title companies. You can close at the same title company, which might save the client a small amount of money, but some agents feel that having separate title companies offers each party an unbiased title support. Again, totally up to you and your clients. Okay, number 3 is going to cover earnest money. So typically you'll see 3 to 5 days written in that first blank. This is negotiable and it's up to the seller and buyer to determine what's acceptable to them. Line 160, here you're going to put the name of the holder, who is the title company and who will hold the earnest money. Dalton Wade does not hold earnest money, as most real estate companies don't. Line 162, the amount of earnest money should be put here. Typically, we see 1% of the purchase price. So this will be the money that the buyers are putting at risk, because if they default, they could lose it. So the more money you put in, generally the stronger your contract is. So this is why it's super important to meet all of the contractual deadlines. Failure to receive earnest money or trust money. So if the earnest money is not delivered in the agreed amount time, the buyer has 1 day to deliver the funds to the title company. And if this doesn't happen, the seller can then terminate. An important note, if you are the one to deliver the earnest money to the title company, you must get a receipt. Super important. Handling of earnest money upon receipt. So this just reiterates why it's a good idea for the buyer and seller to have different title companies upon a written agreement signed by all parties. And number 4, so closing date. You're going to put the closing date at 4A, day, month, year. Please note you can close on an earlier date if desired, as long as it's agreed upon in writing. Number 1 is possession. So select whether the buyer wants to take full possession at closing or if there's a temporary occupancy agreement. This could apply if the sellers need more time to move out and will be living on the property for a time after closing. And prorations. All real estate taxes, dues, maintenance fees, and association fees for this property for the calendar year of the sale will be prorated as of the closing date. Okay. And then we have green belt. So here you're going to check whether the buyer intends to maintain the property's green belt status. And D covers special assessments. If there is a special assessment approved, it must be paid by the seller before closing unless otherwise agreed upon. And E covers warranties. So if the seller agrees to transfer any interest in manufacturer's warranties or service contracts to the buyer, if applicable, and the buyer is responsible for any association fee transfers. Number 5, title and conveyance. The seller agrees to convey a good and marketable title to the property. If there are liens or other encumbrances discovered, the buyer can either accept the property or require the seller to fix the issues before closing. Lines 247 to 250. Good and marketable title is to be determined using a title insurance company using a title search abstract as evidence. And then B, the buyer acknowledges they are not sanctioned foreign government agents or sanctioned non-resident aliens. C covers the deed. You're going to put the names the buyer wishes to be on the property deed here. All the buyers who wish to be on the deed must put their full, it must be their full legal name. The association lien payoff. So if the property is subject to a mandatory special assessment, the seller has up to 7 days before closing to deliver proof of payoff. And number 6 covers public water or public sewer. If it's discovered that access to a public water or sewer system runs through the property, the buyer must notify the seller in writing, and the seller and buyer will have 5 days within written notice to negotiate payment for the cost to be connected to the public water or sewer system. If the buyer and seller can't agree, the contract can be terminated. If the buyer terminates, they can receive their earnest money back. Lead-based paint disclosures. So you'll select the box that applies. And number 8 covers inspections. So any inspections will be made at the buyer's expense unless otherwise agreed upon. All inspections must be done by a licensed professional. However, it's important to know that the buyer can do their own inspections if they so choose. The seller must allow all utility services to be running so that the buyer can reasonably complete their inspections. The buyer has no right to demand repairs of a cosmetic nature and agrees to indemnify the seller of any acts related to the buyer or the buyer's inspectors. Please note that the buyer and their inspector cannot drill holes into the wall or damage the property in any way. All inspections must be made to the aspects of the home that are accessible visually. Very important. B covers the initial inspection. Inspections must be done during normal business hours. Reasonable access must be given to the property's components such as heating, cooling, plumbing, electrical, structural components, roof coverings, and any areas that need environmental inspections. Wood destroying insect infestation report. If this report is desired by the buyer, it is to be ordered and done at the buyer's expense and must be performed by a state licensed pest control operator. Always check with the lender if this report is needed. It's going to be most common in VA loans. And the buyer's inspection and resolution. So insert the inspection period here. Typically, we see 10 to 15 days. Some buyers want a more attractive offer and will put 5 days, but please be aware that that's a very short time period to do all of the inspections. So if the buyer fails to make the inspections within this time period, they are therefore agreeing to accept the property as is. After inspections are performed and when the buyer gives notice, the buyer will do one of 3 things. Either terminate the contract and furnish the seller with a list of objections, accept the property as is and request no repairs from the seller, or give the seller a list of requested repairs. The seller and buyer then have X amount of days of written notice after written notice to review the list of requested repairs. Receipt of these repairs by the seller marks the end of the inspection period and the start of the resolution period. Both parties can now begin to negotiate repairs, and the buyer has the right at any time to retract their repair request and accept the property as is. The resolution period will end with a refund of the buyer's earnest money deposit unless one of these things occur. The seller and buyer enter an agreement for repairs or replacements. The buyer provides written notice to the seller that they accept the property as is, and the seller and buyer extend the resolution period to allow more time for deliberation. The buyer also has the option to waive the resolution period. And then waiver of all inspections. The buyer has the option to waive the inspection contingency, although this is not advised. Number 9, completion of repairs. If the buyer and seller do not agree on repair completion, the buyer will use the final inspection period to determine if repair requests have been met. If the repairs have not been made, the seller is considered to be in default of the contract, and the buyer may terminate the contract and receive their earnest money back. An important note is that all repairs must be made in a reasonable and professional manner. Final inspection. The buyer has the right to conduct a final inspection. And you'll fill in the blank under how many days prior to closing your buyer wants to do it. So usually this is going to be 2 to 3 days prior to close. The inspection is used to confirm that the property is in the same or better condition as it was on the binding agreement date. Final inspections also offer the buyer a chance to make sure the seller hasn't taken anything that was supposed to stay with the property. Number 11, the buyer's additional due diligence options. If any of the below are of concern, the buyer should address them in the special stipulations section. Survey and flood certification. So the buyer may obtain a mortgage inspection, boundary line survey, and or flood zone certification if they choose. And if the buyer's responsibility, it is the buyer's responsibility to investigate the insurability of the property and to gather all the necessary documentation. It is also the buyer's responsibility to make sure the property is meeting local and state water supply laws and requirements. And it's also the buyer's responsibility to make sure the property is meeting local, state waste law requirements. This may include a septic inspection letter. Title exceptions. So the buyer should be aware that their property use may be limited to subdivision and condo declarations, covenants, restrictions, and easements of record. A disclaimer here is that for number 12 is that it's important to read this section carefully and make sure the buyer understands that the real estate agents and their brokers are not parties to the agreement and don't assume any liability for either the buyer or seller. So the buyer and seller agree to not hold the brokers responsible for any of these items. Matters which could have been discovered in a survey, title search, flood certification, property inspection, insurability of the property, geological issues, or anything arising from failure to inspect. The costs associated with making repairs, the cost of removing hazardous materials, tax or legal consequences, availability, capability, and cost of any amenities, information on the school district, appraised or future value of the property, square footage or acreage, any conditions of the property that may affect the property, terms of financing, and zoning uses. The buyer and seller acknowledge the brokers are not experts in any of the above fields, and the buyer and seller understand that photographs and other marketing material may be in use after the property has sold, and the brokers are not liable for any continued use which is outside of the broker's control. So number 13, the brokerage. The seller agrees per their separate agreement to pay the listing brokerage the agreed upon compensation. If the buyer defaults, their earnest money may be forfeited to the seller, and the seller remains in their right to sue if they choose. If the seller is in default, the earnest money deposit goes back to the buyer. The buyer will also be in their right to sue the seller if either party sues due to breach of contract. The winning party can collect all costs, including attorney's fees. And number 15, you're going to choose whether the buyer wants a home inspection plan or not. If one is being chosen, fill in the blanks on lines 421 to 423. This is also referred to as a home warranty, and it covers items like appliances, plumbings, etc. This contract cannot be assigned to a third party without the seller's written consent. Number 17, other provisions. So this agreement is for the sole benefit of the buyers, sellers, their heirs, and successors. This agreement should be recognized as the only one between all parties unless otherwise stipulated. And anyone who is an approved assignee to this agreement must agree to fulfill all the terms. The binding agreement date is the date and time in which the last offer or the licensee of the offerer received notice of the offeree's acceptance. Tongue twister there. B is the survival clause. So any contractual provision that must be completed after closing will remain in effect and be fully enforceable after the closing date has passed and the deed has been delivered to the new owners. Governing law and venue. So this contract is subject to the laws and courts of the state of Tennessee, and everyone involved in the transaction must be aware of the assigned time frame and the consequences of missing a deadline. Basic verbiage is going to be explained in E terminology. So an important note is that the term days means calendar days ending at 11:59 p.m. If a performance deadline lands on a holiday or weekend, the performance deadline will fall on the following business day. Both parties must make a reasonable effort to cooperate and to perform all duties laid out in this agreement. The buyer and seller agree to work together in fixing any errors resulting from clerical mistakes, even if they happen after closing. All notices and demands should be delivered to the other party by email, fax, postal service, mail, or overnight delivery, and of course, can be delivered by just in-person methods. Risk of property loss is assigned to the seller until the property title has been transferred to the buyer. If the casualty loss prior to closing is more than 10% of the purchase price, either the seller or buyer can terminate the contract and release the earnest money back to the buyer. Equal housing. So both parties acknowledge this transaction abides by equal fair housing laws and severability. This clause aims to keep the contract intact. So instead of this agreement ending based on a single portion that might be disagreed upon, the parties may continue to meet the terms outlined in the enforceable sections. Skipped a couple pages here. Sorry about that. Okay, so alternative dispute resolution. The resolution of disputes by mediation, the mediation addendum or amendment will be used if and when appropriate. And it is agreed that both parties share equally in the construction of this agreement. Section headings are for contractual reference only. And before entering into an agreement with the buyer, the seller must disclose in writing the presence of a well or sinkhole, the results of any percolation tests or soil absorption rates that will be acceptable by the Department of Environment or Conservation, if the property is located in a PUD, and if it isn't a PUD, they will make available a copy of the development's covenants, bylaws, and master deed. If any single family residence has been moved from an existing foundation to another foundation on the property, and if a permit for a subsurface sewer disposal system was issued during a sewer moratorium. So digital signatures are accepted by both parties and are enforceable by law. Any exhibits or addenda should be listed in the number 20 spot. And any special terms you've worked out with your broker should go in number 21. If there's anything applicable to the contract that conflicts with the preceding section, that verbiage will go in this section. And time limit offer number 22. So this is how long the buyer will be given, is giving the seller to accept, counter, or reject the offer. And then all parties will sign and the seller will choose whether they accept, counter, or reject this offer. And that is all for today. We have your support team listed here as always. I will be sending you the recording of this training today and the slideshow, of course, as well. I'm going to stop sharing and stop recording and open it up for questions now.